you all hear me okay without the mic? Yes. I'd just like to thank Jane and thanks to all of you, and apologies for having to change the schedule. The referendum in 4 weeks is sort of taking over our lives, and unfortunately I have to go after this to, as Jane says, to some work on the referendum. But I'm delighted to have the opportunity of speaking with you today. And I suppose given the time slot I'm in, I could perhaps be regarded as a sort of pre-lunch appetizer, kind of a human canapé, if you like. But I hope what I have to say won't put you off your appetite for lunch in any way. On a serious note, I'm delighted to speak with you on the topic of the mediation bill, because I'm a member of the Joint Oireachtas Committee on Justice, Defence and Equality. And on that committee, as you know, we've done a good deal of work on the heads of the mediation bill. I know it's a topic very close to your own organisation and to the work of your organisation, and I thank Jane for giving me information about the work you're doing on this, and in particular for developing your own mediation training and the establishment of training courses in commercial mediation, court alternative mediation, workplace and planning and environmental mediation. That's hugely important work. I know you're in the process of holding a 5th commercial and workplace mediation course. So these are groundbreaking steps that are really being taken by yourselves in order to train professional mediators. They're steps that are very much in keeping with the government policy of developing mediation processes and developing ADR generally. And the programme for government, as you'll be aware, which was agreed in 2011, stated then that we will encourage and facilitate use of mediation to resolve commercial, civil and family disputes in order to speed up resolution of disputes, reduce legal costs and ameliorate the stress of contested court proceedings. So those were noble aspirations. Clearly there's been a rather a delay, a rather lapse of time since that noble aspiration was set out. So I want to speak with you about what has been happening and what is and the recent developments. As you know, the Minister for Justice, then Minister for Justice Alan Shatter, published the heads of the mediation bill in March 2012, and he forwarded them to our joint committee, our Oireachtas Committee on Justice, Defence and Equality, to give us an opportunity to scrutinise the heads. And as you'll be aware, this is a relatively new process in the last few years, where Oireachtas committees are given heads of bills or schemes of bills at an early stage in order to hold consultations, to hold hearings, and to invite submissions from interested parties and stakeholders. The idea is that this will influence the shaping of the legislation at an early stage, and we will take the hearing, take submissions, take hearings, and then forward a report to the relevant minister. So it's a unique opportunity to influence the shaping of the bill. And I know that your organisation was one of the quite a number of groups that came in to address us in May 2012 on the heads of the mediation bill. We've done this quite successfully with quite a number of other bills in the Justice Committee. What did the bill, the heads of bill, of course, will place mediation on a statutory basis. They're significantly influenced by the draft legislation produced by the Law Reform Commission in 2010, as you know, and of course they should also be read alongside the relevant SI 209 of 2011, the European Community's Mediation Regulations, which transpose the requirements of the 08 Directive. But in short, again, as you'll be aware, the general objective of the bill is to promote mediation as a viable, effective and efficient alternative to court proceedings throughout a range of civil, commercial and family law disputes. And I've previously addressed family law practitioners on the topic of the mediation bill, but clearly the concerns of family law practitioners are rather different. You know, they're very much focused on the family law mediation processes, which are already quite developed. So, you know, there's quite a range of different interests at stake when you talk about these different aspects of ADR. But clearly the bill will go well beyond the established mechanisms in family law and in the workplace, and the idea is that it will bring about reductions in legal costs, speed up disputes, and, as I say, relieve stress for parties. So a number of key provisions in the heads. They will introduce an obligation on solicitors and barristers to advise parties to disputes to consider using mediation as a means of resolving them. They will provide that the court may, on its own initiative, following the commencement of proceedings, invite parties to consider mediation, provide the court proceedings may be suspended to facilitate mediation, provide communications will be confidential, provide costs of mediation must be reasonable and proportionate, and provide for establishment of a mediation council and the introduction of codes of practice. So you'll be aware of what's in the bill, what's in the heads of bill, I should say. And at the hearings, we heard submissions from yourselves, from the Centre of Effective Dispute Resolution, Family Mediation Ireland, the Dublin Solicitors Bar Association, Irish Commercial Mediation Association, and the Mediators Institute. So a broad range of bodies. All those who participated broadly welcomed the proposed legislation and agreed it would provide for greater access to justice as a common fee, which isn't always the case. More recently we did hearings on the Children and Family Relationships Bill, where we had much more contested issues really to deal with, much more just difference among submissions. Here we had a much greater consensus among the bodies that submitted to us. What we found was that stakeholders generally suggested public awareness of the option of mediation needs to be addressed. Lack of awareness, I should say. It's currently the case that quite a number of parties, as you'll be aware, involved in disputes will seek recourse to the courts almost as a default because they're not aware that mediation is an option open to them or don't understand the processes. That's one of the key issues the bill has to tackle that we said needs to be addressed. And the committee welcomed Head 4 of the bill, which provides solicitors, as I said, must, prior to commencing civil proceedings on behalf of the client, advise them to consider using mediation. But we recommended strengthening this duty and investigating whether an obligation should be provided, for example, of other parties beyond the solicitor on the court service, for example, to make information available to potential litigants. Of course, the lack of awareness is compounded by the fact that there's no single list or register of mediators. So, I mean, as a number of the stakeholders said, you know, anyone can put up a sign describing themselves as a mediator. Potential clients have no way of knowing if somebody has any particular code of conduct that they're following. And so we concluded a national register should be introduced for mediators and a common code of conduct. And again, these were not in any way contentious or controversial recommendations. The absence of adequate regulation for mediators was another key issue raised by stakeholders, and the lack of a central system of redress or complaint for persons with problems either with the process or with an individual mediator. Obviously, some organisations have their own internal complaints procedures very well developed. But we felt it was would be desirable to have a more comprehensive mechanism so that mediators would all be subject to the same grievance procedure. But of course, you know, I mean, that's perhaps focusing too much on the negatives. We were very conscious, and the submissions were very conscious also, that the great positive advantages of mediation are enormous. You know, that the potential mediation can offer for dispute resolution in a non-adversarial fashion, and it has significantly reduced costs. These are immense advantages that even an adversarially trained criminal justice lawyer like myself, you know, can really appreciate this. And I should say that's my own background, in fact, is criminal law and criminal practice. But turning to what makes mediation successful, the groups told us that confidentiality is the key aspect of successful mediation, and that as you know, is in the bill. That the integrity of the process relies on this understanding of mutual confidentiality. But it was suggested to us that although it's already in the bill in Head 10, that Head 10 should be strengthened and that statutory protection should be provided for mediators against being called to give evidence in subsequent legal proceedings unless it's overwhelmingly in the interest of justice that the mediator gives such evidence. That there be a presumption that they wouldn't be giving such evidence. I know you want even views on that. Finally, we considered the issue of the withdrawal of a mediator. Some of those who submitted to our committee stated that the heads appear to oblige, in their current form, appear to oblige a mediator to give reasons if they wish to withdraw. We thought this was not in accordance with best practice, and this is what we were told. And we published our report, which is on the Arbitrators website, in June 2012. We sent it to the then Minister for Justice, but clearly that's well over 2 years, nearly 3 years indeed, since then, and we still have not seen the text of the bill. So I just wanted to conclude by talking a little about, you know, post-legislative scrutiny, post the report and the pre-leg scrutiny, what has been happening. Well, in the Shannon, we've been trying to push things forward, you know, and I must say that this has been on an all-party basis. And a number of us spoke in a debate on the Shannon on mediation services this year on 4th February. And again, the text of the transcript of the debate is on the Arbitrators website. And all of us, and again from all parties, both government and opposition, criticised the delay of in the government's bringing forward of the mediation bill itself. And indeed, the senators agreed on the motion, which was on the need for the government to commit to the publication of the bill. So, and I asked this week, in light of the invitation from Jane, I asked the Department of Justice for a further update. I think we received one in February. I asked them for a further update in advance of today's speech. And some of the, you know, what they've told me is what people will generally be aware of, I think, that a number of developments have been taking place following the publication of our report. First, the Department of Justice has been in consultation with the Legal Aid Board, which has responsibility, of course, for the Family Mediation Service. And this is specifically on a new provision to be included in the bill, concerning the provision of mandatory information sessions in family law cases involving children. This again was something that came up at our committee hearings, with the need for a specific provision on this. More significantly, perhaps for your members, further consultation is also being undertaken by the Department with various bodies in the mediation sector, and you'll be aware, I think, of this, to discuss the issue of the regulation of the sector. And again, as I've said, an issue that was highlighted again and again by those who submitted to our hearings. The discussion ongoing is focused on the establishment of an oversight and development body made up of representative bodies in the mediation sector. And the body would have a number of functions, I understand, that to promote the public awareness of and provide information to the public about the availability of mediation services in the state, so that's addressing this problem of lack of public awareness. The body would also maintain and develop standards in the provision of mediation services, prepare codes of practice, another issue, as I said, we focused on, prepare codes of practice for mediators for approval by the Minister, oversee the application of any approved code, establish and maintain the register of mediators who subscribe subscribe to the approved code, and of course then specifically on family law cases advise on the establishment and operation of mediation information sessions in that area. And again, you'll see in the heads as currently drafted, and I think in the heads that are being revised, this focus on the need to ensure specific application of provisions to family law settings. So, where are we at? That's the discussion that's ongoing. When are we going to see the bill? So I'm assured that the mediation bill is currently being drafted in the Office of the Parliamentary Council, although I have to say there's an awful lot of bills currently being drafted in the Office of the Parliamentary Council. They are very much overloaded, we're conscious of that. The bill is on the government's B list, as any of you who've looked at that will have seen, for the current term, the spring-summer 2015 legislative session. Publication date on that list is described as being late 2015. The Minister has said she intends to proceed with enactment of the legislation as soon as possible following publication. So publication is in the autumn. Certainly we would strive to see the bill enacted in a short few months following that. So to conclude, I and my colleagues on the Justice Committee are very concerned, as I've said, and indeed my colleagues in the Shannon more generally, are very concerned at the lack of progress on the mediation bill. And being invited to speak at events like this really do, I suppose, bring home to us the need to keep the pressure on the department and on the government to ensure this bill is brought forward. We're keen to see the bill enacted by the end of the year. I must say that we can't get a firm commitment to that from the Minister, but I think that may well be her intention, and certainly we'll be pressing her on that. And after all, I suppose, as your members, more than anyone else will be aware, mediation truly is the future as far as dispute resolution is concerned. As an ADR mechanism, we know, and we were told in very impressive submissions before the Justice Committee, that the development of mediation, and in particular of a comprehensive statutory framework for mediation processes, that Ireland could become a leading centre for international ADR and mediation, and that really is a goal for which we should all be striving. So I'd like to assist you in any way I can and give support to you and to those who are pressing for the introduction of the bill, obviously for an improved version of the bill taking into account the recommendations and the ongoing consultation. But with that in mind, can I just finish by wishing you bon appetit, enjoy your lunch, and thank you again for the opportunity.